Well, good evening and welcome to the ELI Young Lawyers Award. Also, like the whole annual meeting of the ELI this year online. But we want to try to keep the order of our meeting as we always had it. And also this year, we're very lucky that we had several submissions for the Young Lawyers Award. Very, very interesting papers. I can only say that. But of course, at the end, as always, when you are a jury, you have to make a choice. And this year, we selected a paper written by Alina Skilic on health data, inferences, an explored volcano eager to erupt post-COVID-19 crisis. And the subtitle is Aligning Inferences with GDPR Principles. Now, what Alina has done in her paper is that she makes clear that health data are so, of course, directly connected with your person and your personhood that privacy protection should be the absolute baseline. That is where everything that happens with these data should start. They are a part of you. They are your health. They express in part who you are. But of course, health data are necessary also for medical services providers, for hospitals, institutions, to use, to cure you, also to do research, academic research, but also research by the pharmaceutical industry to develop a vaccine. And what we see is that the development of these vaccines goes extremely fast, where this afternoon I read a paper that only a few years ago, it took about 10 years to develop a vaccine that would work and that you could actually use in a responsible way after testing it. Now, with the use of, for instance, genomic data, artificial intelligence, it might take 10 to 12 months, and that is exactly what we are experiencing right now with the development of the COVID-19 vaccine. So the industry also has to play a role here. And what she argues in her paper is that that role definitely should be recognized as such, but should be regulated together with the pharmaceutical industry, but each time remembering that we are discussing the patient's data, personal data. The paper is very well researched. It is clearly written. It reads in a very pleasant way, and it provides, in my view, workable solutions for these very sensitive data, which health data are. And it is therefore with great pleasure that we give Alina the award. Now, last year, John North from Interlegis and I could give the award, of course, physically to the winner. That is not possible this year, but we do have Alina, and my congratulations with winning the award. But again, I cannot give you a real handshake. I'm not allowed to, and on screen, that's absolutely impossible, but still a virtual handshake. We have a picture of the award, which, if everything goes well, will now be on screen. So congratulations again, and consider this as handing it over in the form of a digital asset, but you will get the actual thing. Okay, congratulations again. It's now my pleasure to give the floor to John North, the president of Interlegis, who is sponsoring us and who will also say a few words about your paper. John, the floor is yours.
Thank you, Chef. Well, first of all, I would really like to congratulate Alina for winning the award this year. I'd also say how pleased I am to be able to join the webinar today and be part of the European Law Institute AGM. A great program has been put together, and so I'm sure that the event will be a great success. I've been asked to reflect a little bit about our involvement with the European, or the ELI Young Lawyers Award, so perhaps I'll start with that first. We're proud, as you say, to be a member of the Institute, and again sponsor the Young Lawyers Award in 2020. Interlegers as an organisation shares many of the same aims as the ELI, and so recognise the importance of learning of the achievements from different cultures, sharing knowledge and taking an international perspective in dealing with complex legal issues when those arise for our clients. The organisation was founded back in 1989 by a small group of like-minded law firms who saw the opportunity and benefits of strengthening links in other jurisdictions at a time when boundaries in Europe were coming down. We recognised from an early date the importance of encouraging and recognising young lawyers as being the voices and leaders of the future, whether you're viewing the law from an academic or commercial perspective. Indeed, for a number of years, Interlegers organised a similar award to the ELI Young Lawyers Award, which was aimed at undergraduate and postgraduate students or newly qualified lawyers who were at the start of their careers. That has now developed into a secondment scheme where we send young lawyers to work, produce a paper on either a legal issue or a law management firm issue of international interest. And they're based at another member firm in our network. As I say, we're proud to have been the sponsor of the ELI Young Lawyers Award for the last 3 years and to see how it has developed since its inception in 2016. The benefits of award schemes are sometimes questioned, but to me, the Young Lawyers Award scheme more than fulfilled its objective of giving the young European legal community a mechanism to propose practical suggestions for improvement of European law and so contribute to the improvement of that law for the benefit of citizens and businesses alike. Wisdom arising from because of experience is of course important, but in today's fast-moving world, it is essential that we benefit from the input of the young, as they often have a different perspective and different solutions, more creative solutions, on the issues to be addressed. This year's entrants were, as Chef said, again of extremely high quality and covered a broad range of topics. As a practicing lawyer of over 30 years experience and judge of the ELI Young Lawyers Award for the last 2 years, it has been gratifying to see the knowledge and talent displayed by this and previous year's entrants. Previous year's winners have written on topics as diverse as blockchain, competition law, or the European arrest warrant. As Chef has said, Alina has stood out in terms of the entrance this year, and I thoroughly agree with what he said about her submission. She brought clarity and insight into to me an intriguing aspect of data protection law. For a corporate and commercial lawyer who has had from time to time to advise clients, get into grips with the intricacies of GDPR and implement its requirements, it was interesting to have my eyes open to an aspect of data protection law which I hadn't really considered in any depth before. In particular, as has been said, the data law issues that can arise from the private sector drawing perhaps incorrect inferences about the health of an individual and the potential consequences of that. For example, where the inference drawn by the hotel might result in the unjustified, different and potentially unfair treatment of an individual simply on the basis of the origin of their travel or recent travel history. This issue has, of course, been brought into sharp focus by the crisis caused by the current pandemic. I'm sure that you, like me, have been asked to complete questionnaires inquiring into our recent health and travel history before being allowed to check into a hotel. Only this weekend I'm going to stay in a hotel and I've been required to fill in quite a detailed questionnaire. We're asked whether we have any symptoms and asked to take our temperature. I'm not sure that many people in the current circumstances question the validity of the request being made or query what the hotel or other business will do with the personal data after they have obtained it. Alina's submission analyses and brings clarity to these issues and offers a solution by recommending that precise and binding guidelines on inferred data processing be adopted. All of this, I think, to happen after lessons have been learned and the dust has been settled from the current crisis. I do not want to give too much more away, on the content of Alina's submission. And so on behalf of Interlegis, I would like to congratulate her again for being the winner of the ELI Young Lawyers Award 2020 and hand over to her so that she can give a presentation on her excellent submission. So Alina, the floor is yours.
Thank you, and thank you very much, Mr. North and Mr. Van Erp, I hope I pronounced that correctly, for the introduction and for your congratulations. It's a great honor to participate in the ELI Annual Conference, and especially as a winner of the ELI Young Lawyers Award 2020. And thank you very much once again for this great award and for finding my paper interesting and important. So I would first like to refer to how I got the idea for this paper in the first place. I am an associate at a law firm, and my everyday work is specifically focused on privacy and data protection law. So naturally, when COVID-19 hit Croatia, I started thinking about possible privacy implications which COVID-19 might raise, as it was naturally expected that extensive collection and processing of data concerning health will follow the efforts to combat the virus. So I would structure my presentation of this paper by first explaining the concept of data concerning health and their sensitive nature and the possible legal basis for processing. And then I would explain how, where legal basis cannot be easily or at all defined in case of processing by private sector, how private sector could use inferences for protecting their interests, such as ensuring safe stays in hotels in an unlawful way. And I would further elaborate on the possible risks for data subjects. And finally, I would say a few words about recommendations to regulate processing of health data. So firstly, data concerning health is basically personal data related to the physical or mental health of a natural person, which reveal information about his or her health. It includes any data which reveals anything about the state of someone's health. And in light of COVID-19, data concerning health would be body temperature, medical status such as COVID-19 positivity or negativity, COVID-19 symptoms, and similar. And naturally, as COVID-19 is a health disease, broader health data processing was expected. And the processing of health data is generally prohibited under GDPR, generally, as certain exceptions, I mean, legal basis for processing exists. And when COVID-19 hit Europe and the world, data protection authorities reacted pretty fast and issued guidelines on the processing of health data. But these guidelines concerned only processing by public authorities and employers, which was understandable, as at the time, private sector was, let's say, on hold. So I used the hotel industry as an example because tourism, hotels, accommodation industry was one of the most affected industries at the time by COVID-19. And I started thinking, what will happen when the industry gets back on the track? Will they be able to process health data, such as asking their guests of their medical status? And if not, do they have any? Are there any unlawful ways of processing that they have at disposal, which they can use to protect their business? So the health data, the processing of health data, in order to be justified and aligned with the GDPR, data controllers need to have two legal bases. One is primary, such as basic legal basis from Article 6, which is consent or contract, or such as legal obligation of a controller or legitimate interest, vital interest, etc. And they must have additional legal basis, which is a legal basis specifically for sensitive data processing, such as health data. So while I was analyzing the first legal basis, I'm sure that they might find it, whether is it a consent, whether, although I would argue that consent is applicable legal basis, as it might not be considered freely given if, for example, entering the restaurant in hotel or entering the gym is conditioned upon the consent, but there might be a legal basis in member state law which legitimates the processing of personal data, health data. But the problem arises with the second legal basis, which must exist for health data processing, as was while I was analyzing the Article 9, which prescribes the health legal basis. I wasn't able to find actually any which would make a processing of health data by hotels or accommodation sector or tourism sector legitimate, because mostly Article 9 considers public interest, but even when public interest is applicable, it has to have legal basis in member state or union law. And whenever public health is mentioned as a legal basis, it basically refers to processing by public health authorities and I don't know, doctors, hospitals. So public health is in center and not processing by private sector. So when I realized that it would be hardly for hotels to find a legal basis, I started thinking if they will seek a way of processing data concerning health in a non-lawful way, as it would be really hard to imagine that with COVID around, private sector would continue operating business as if COVID is not around or has never been, without any additional level of carefulness, at least when, I mean, we can only consider their reputation. No, hotel does not want to be seen as the place where the virus spreads, or I don't know, put their guests or employees at risk. So if they cannot process data concerning health lawfully and transparently, does this open a space for hidden data processing? And this is where inferences come or might come into question. And inferences are not, unfortunately, highly discussed topic or addressed issue. And I found that the Information Commissioner's Office, the DPA of the United Kingdom, is one of the few regulators which specifically refer to inferences when speaking about sensitive data processing. And I am familiar with inferences in terms of intersection of privacy and technology, as technology today can produce inferences, but I realize that we don't need actually technology to process personal data inferences. So inferences are information relating to identified or identifiable person through deduction or reasoning rather than through mere observation or collecting from data subjects. Inferences have two very important aspects. The most important one, which distinguishes them from other forms of personal data, is they are not provided voluntarily from data subject or lawfully obtained by third parties or other sources, but this is data which is created from such data. And as such, they are at risk of being not verifiable, and especially when they can result in important decisions. And practically speaking, inferences are assumptions or subjective assessments based on information we possess, and that assumption might be under certain conditions considered personal data and even sensitive personal data like health data. And the second important aspect of inferences is that they do not have to be correct to be considered personal data. What is actually important is that they are used to make decisions. And this follows the guidelines from ICO, which argues that two things should be assessed when determining whether an inference constitutes personal data and sensitive personal data. Well, firstly, it may be impossible to infer or guess details about someone which fall within the special categories of data, depending on how certain that inference is and whether that inference is deliberately drawn. But if it's just a possible inference, then that would not be considered personal data unless someone is specifically processing that data to treat someone differently on that basis. So to give you an example, which I also gave in my paper, I used the example of how a hotel could use an origin of travel of its guests, which is a non-sensitive data, and which is a data which hotel industry lawfully processes and for which they have legal ground. How they can use origin of travel to infer the risk of being infected by COVID-19. For example, being considered positive or negative, which is a sensitive personal data. In other words, how hotel could consider the origin of travel as a parameter of likelihood of infection. For example, guests coming from highly affected areas are classified as possibly infected. And that suspicion of someone's health status, if processed for certain purposes in order to make decisions, is sensitive health data. Well, it is really important to clarify that someone's health status cannot be inferred from origin of travel with reasonable degree of certainty, which means it would not be an inference if we look back at the definition on inference, unless a hotel is processing these inferences to specifically treat guests on that basis. And it is thus not relevant if an inference such as possibility of COVID infection from origin of travel is correct or certain if it's used to influence a hotel's activities. And I would just, for the sake of clarity, like to give another example. It's not directly related to hotel industry, but it's very vivid in terms of employment relationships. For example, when employer would request its employees to report traveling to, let's say, third countries which are labeled as risky for COVID-19 infection, and if employer has prescribed measures for those workers who traveled, it is very likely that these measures are then imposed because employer suspects that its employees are infected or possibly infected due to traveling to risky countries. And this suspicion of being infected would be an inference and health data. However, employers possibly have a legal basis, at least, complying with occupational health and safety legal obligations. So this is different from when hotel is drawing inferences. but I thought it would be more clear if I give another example separate of what inference, sensitive inference is. So just, sorry. Well, now that I explained what inferences are, I would like to draw your attention to risks, which drawing such inferences by private sector might, what are the risks for data subjects? So the first risk, which is also an example of using inferences to influence activities, is unfair treatment based on a person's assumed health status. Example would be, let's say that due to the COVID-19 situation, hotel limits number of guests who can eat breakfast at the same time in a hotel, or number of guests who can occupy hotel gym at the same time. And these are reasonable business practices used as a measure to combat the virus. However, not when they are based on the guest's inferred health status, because this, among other things, infringes data subject rights to be reasonably assessed on actual and correct aspects of, I mean, any personal data, but mostly in this case aspects of their medical status. And the second risk is, well, broadly said, unlawful processing of personal data, which diminishes key GDPR principles. And here I would just like to stress out again that just holding or processing the origin of travel in case of hotels is not prohibited, nor it requires sensitive data conditions. But processing origin of travel to indicate the likelihood of COVID-19 infection to make business decisions would be processing of health sensitive data, and would present hidden data processing without respecting core GDPR principles, which GDPR sets in Article 5. And I would like to refer to a few of them just to exemplify how actually the processing of inferences affects these principles. So firstly, there's a principle of lawful, fair, and transparent data processing. Lawful presumes having a legal basis that the processing occurs within applicable law. And I argued at the beginning of my presentation that it is highly unlikely that a hotel could find applicable legal basis for processing someone's health status or, I don't know, request information about are they having any symptoms, etc. Secondly, fair processing is directly linked to the idea that data subjects must be aware of the fact that their data is or will be processed so that they can make an informed decision and be able to exercise their rights. And in addition, fairness also requires assessment how the processing will affect data subjects. And thirdly, the transparency principle means that data controllers must be open and honest about the ways in which personal data is used. And this is probably the principle which would suffer the most, as it is pretty much inconceivable that an organization such as hotel would make exemplify data practices or practices of drawing inferences transparent, which would make data subjects unaware of inferences created about them, and which would additionally also prevent them from exercising their rights, as they have no idea that their assumed health status is being processed in order to make some business decisions. Also, the purpose limitation principle, which requires that data processing has a clearly defined purpose, such as the processing of origin of travel has a purpose. For example, some countries have the obligation to register the tourist with the public register, and they need origin of travel. but purpose limitation also requests that such data cannot be reused for a purpose which is incompatible with the original purpose. And for example, for inferring guest medical status, I mean health status, or COVID-19 positivity or negativity. Also accuracy, which requests that data controllers take reasonable measures to ensure data is accurate, and there is a very high possibility that process inferences, I mean assumptions about someone's health status based on their origin of travel would be accurate. That's really highly unlikely. And I think that I mean, while writing the paper, I also asked myself if there is or could be a way of making these practices legitimate and proportionate. For example, if a hotel would make an inference practices such as using the place of origin to assess the likelihood of infection and accordingly organizing business, if a hotel would make these practices transparent to guests, would that in any case could that be GDPR compliant, or looking at the privacy law in general compliant? And even if one could argue that appropriate legal basis exists, that processing is indeed necessary for some legitimate purpose and transparent, I think it is confident to say that health status should not be subjected to guessing or assuming by a hotel or any private sector other than healthcare experts, which are only the only institutions or individuals who are authorized to inspect and conclude of someone's health. So I, at the end of my paper, and having in mind everything I just discussed and what I wrote in my paper, I also thought about any recommendations or how these practices could be tackled. And personal data inferences have been addressed as a loophole of the GDPR, and as we've seen, this problem might become even more important during and post COVID-19 crisis, and this would be a valuable opportunity to tackle this issue, both for now, considering the crisis, and for the future. And what I would first like to say is that data controllers in general are often unaware of all data categories they process and the ones which they are allowed to process, which leaves space for unlawful data processing and for creating inferences. So I suggested unique necessity test, that is a test in terms of COVID-19, which would show which personal data is indeed necessary for the purposes of private sector, such as purposes of ensuring the safety of business, in terms of hotels for ensuring the safety of their guests and employees. So a unique necessity test on health data processing outside the healthcare industry. And I think what is needed is providing the private sector with clear guidance, and that might even encourage them to consistently ensure that the processing is permissible under applicable legislation. And I think that the effectiveness of such a test would be beneficial if created within a dialogue between both regulators and the industry, and by allowing both sides, that both sides are aware of which personal data might be necessary to contain the risk and to ensure that the business is performed as normally and safely as possible, while respecting the prohibition of sensitive data processing. And looking beyond the COVID-19 crisis, I believe that EU legislation would need an update to deal with the threat of inferences, and the priority of regulators should be to adopt precise guidelines dealing exclusively with inferred data processing. And I'm aware that this might be quite a challenging task. I mean, predicting and regulating all practical examples of personal data under GDPR, as the term of personal data is broadly defined, but I really believe that the legal treatment of inferences should be clearly drawn in the future. So I hope that you enjoyed the presentation of my paper. I hope it was informative, and again, thank you very much for having me here and for giving me the ELI Young Lawyers Award this year.
That was very enlightening and very informative. So thank you for that. It made me think of, well, how difficult the borderline is between personal and non-personal data. Once when you give your consent, sometimes through reverse engineering, what became afterwards anonymous again becomes personal. And basically what you are saying is that data that start as non-personal through a sort of reverse engineering, infer, could become personal, and that we should think of that very carefully, particularly with regard to health data. So thank you very much. It was a pleasure giving the award to you, and I now hand over to the president of the ELI, Christiane Wenderhorst.
Well, thank you so much also from my side, and it was a really interesting talk and a fascinating topic. We're all dealing with inferences and struggling how to treat them under data protection law and also under other legal regimes dealing with data. I'm mindful of the fact that the Hub and SIG Award is only scheduled for 7:45. I was wondering whether you, Chef, are planning to have a brief Q&A on Alina's talk to fill the gap, because we would have 5 minutes. Otherwise, we probably will wait for those participants who have specifically registered for the Hub and SIG Awards. We cannot hear you, Chef. Can you?
Yes, because my screen has all sorts of images on it saying that I'm muted, unmuted, and so on, but I'm now unmuted. Good. Definitely, there is an opportunity for questions. So if there is a question, let me see. The questions could come in through Q&A. We have a separate screen for that. Right. One question came in. I don't know, Alina, if you can read that too?
No.
I'll read it for you.
Thank you.
Okay. Is there a standard for determining the nature of sensitive personal data for individuals? Because some data may be sensitive for a person and not for another person. For example, the temperature of a person may be sensitive data for someone, but it may not be the same for another person. The question is there a vision to give the individual the ability to classify his various personal data and determine the level of sensitivity for each type of that data, and thus determine the appropriate legal way to deal with it according to your vision in this research?
Thank you for your question. Well, I believe that in the first part of the question, if there is a standard for determining the nature of sensitive personal data, is there? Well, in terms of GDPR and the definition of sensitive data and the specific categories of sensitive data, such as health data, I believe that they are regulated objectively in objective manner, such as data concerning health is sensitive data, and it's not a subjective category that for someone body temperature might be sensitive data and for some not. But what I would like to say, it's related to the question. There is a way that the temperature of person would not be considered personal data at all under certain circumstances. For example, we have that in Croatia, our data protection authority issued guidances on how employers can measure body temperature of their employees without that body temperature to be considered personal data. So I think we all up to now experience that when we enter a bank or I don't know, even at our workplaces, they measure the temperature with that small device. If you only measure the temperature so that you can decide whether someone can enter or not, but you're not storing that temperature anywhere. You're not you do not keep, I mean, the records of body temperatures which you measured that day, and if you don't link the body temperature on your device to any identified or identifiable person, so you only measure that and okay, you can enter. According to our Croatian Data Protection Authority, that would not be considered personal data, as it would not be stored anywhere, either electronically in some database, or would not be put on a paper so that they can be structured files in terms of GDPR. So I hope this answers a question.
Well, definitely, yes. You see, the question is about that certain data in some respects might at the same time be both personal and non-personal. And then the question is, how do you deal with that? And it's very, very context specific. And it's quite complicated. And that is what I found so intriguing about your paper, that you drew attention to those questions. So I think we have time for one more question perhaps, but let me see in my chat box. I see no further questions. So, which means, Alina, that I think you've been extremely clear, because otherwise that would have numerous questions. So no questions can either mean that no one understood what you were talking about, or that they completely understood you. And I'm sure you've been so clear and so informative that the answer is you have been really, really clear. So I think, Christiane, this is the moment that we, on behalf of the ELI, thank you again. It was a pleasure hearing you. It was a pleasure giving the award to you. John, thank you for joining us. It's always a pleasure working together with Interlegis, and I think that Christiane can only confirm and affirm that. And I hope we can do this again next year.
Absolutely. A great pleasure for us too.
Congratulations again to the winner, and our great gratitude to Interlegis for having again sponsored this award, which is so important for the next generation of lawyers. Thank you again, and have a nice evening.
Thank you.
Thank you.
Thank you.
So, colleagues, we're coming to another important step, which is the Hub and SIG Awards. As you are aware, hubs and SIGs are a very important part of the ELI's life, because it is hubs and SIGs where members can communicate and meet close to their home countries. They can maybe discuss in their native languages as far as hubs are concerned, and they can dive very deeply into specific subject areas as far as SIGs are concerned. And if you attended today's membership meeting and you heard the report given by Anne-Brigitte Gabniard, you will have realized how important those hubs and SIGs really are for the ELI. And we really rely on these communities to discuss current and topical issues. And it has been on various occasions that the hubs and the SIGs have been extremely helpful in scanning the horizon, in identifying the most pertinent topics, which have then in various cases also developed into ELI projects. But there's a number of other activities which hubs and SIGs are pursuing and which are so valuable to us. And this is why we have started to have awards. And my desk is very small, but it's very crowded at the moment. So there is, if you see this trophy, there is an SIG of the year. And here we also have a lovely document for the SIG of the year. So you will all be wondering who is the winner of that SIG of the year. Well, we had a very tough time, I can tell you, discussing who would be the winner this year. It was not an easy choice at all, but we then looked at the number of meetings, the impact meetings had, and then we discovered there was an SIG that not only met at the last annual conference, had a side meeting in Vienna, but that also organized a panel on algorithmic regulation and legal services. An SIG that had a conference in December 2019 on contracts for the supply of digital content and digital services in Milan in Italy. Then in April, when the COVID crisis had already hit us, there was an online seminar on COVID-19 tracking apps, balancing public health and data protection. So I don't know whether you, Alina, had joined that seminar. It would have been very interesting for you probably. Then in May, there was the next online seminar on virtual shareholder meetings driven by COVID-19 and blockchain technology, ? And in June, the third online seminar on how digital platforms react to the COVID-19 crisis. And we were so impressed by these achievements of that SIG, and you will have guessed by now which SIG I am referring to. It is, yes, again, the Digital Law SIG. We can't help it. They're so good. So they won last year's award. They win this year's award. So congratulations to the chairs of the Digital Law SIG. Hello, Christoph. Welcome to this event. I hear Alberto cannot make it, but you're here to take the award. Now it's very difficult. I don't know how our secretariat has envisaged handing this over virtually. So I am moving this into the camera, and now you all have to imagine that Christoph has the award in his hands. Christoph, we're really proud of you. Yeah, you can be proud of yourselves, and we're proud of what you're doing and what you're achieving. We really feel that Digital Law SIG has an impact in Europe, which may, of course, to a certain extent also be due to the fact that there are no or not so many established digital law associations around. So I think your SIG really fills a gap in the European landscape. I think people are really looking forward towards all these events you're organizing. They really have a crystallizing function for the digital law society in Europe. So that's really a great achievement, and we're proud to see what you're doing and the impact you're having. So Christoph, I don't know, would you like to say a few words to our members and explain to them maybe what is the story that behind your success? So how can you be so successful?
Thank you. Thank you very much, Christiane. I must say I'm thrilled and humbled by the ELI's decision to offer this year's SIG award again to the Digital Law Group. And of course, this award goes to a group of ELI fellows, more than 100 fellows working in the field of digital law. And I can say that it is a great privilege and a pleasure to chair this group of fantastic people together with my dear friend and esteemed colleague Alberto De Franceschi, who couldn't join us tonight, but who is sending his greetings from Ferrara. As you know, the past months have been difficult because many activities that we had planned could not be realized, could not take place because of the pandemic. But then we decided to go digital. After all, we are the Digital Law Group, so we thought that's appropriate. And we came up with the idea of hosting a series of digital lunch talks, which actually was only a sort of ersatz for the meetings that we had planned. But we were overwhelmed by the enthusiasm of ELI fellows who attended these webinars on topics, as you already said, like virtual shareholder meetings, COVID tracing apps, how digital platforms react to the pandemic. And I think it somehow shows the spirit of the Digital Law Group members, how we somehow managed to turn a necessity into a virtue in this situation. So thank you very much again to the ELI fellows who contributed to this. And finally, I can promise you that we are not running out of ideas. We still have ideas for possible projects in the pipeline. As you said, in the past, the Digital Law Group was a sort of incubator for ELI projects. And the next, let's say, small project that we are planning is a workshop in December, where we want to look at the Digital Services Act and how it relates to the ELI platform model rules. And we also look to new topics like online dispute resolution. So there is more to come. And we hope that the Digital Law Group can further serve the ELI's mission and contribute to building the ELI community. So thank you very much again for this wonderful award. Thank you.
Well, thank you, Christoph, and thank you, Alberto, and thanks to all those fellows who are active in the SIG. It's really great what you're doing, and we're convinced that you will continue serving the ELI's purposes. We're really looking forward to that conference on the Digital Services Act. And again, thanks to a number of you who have contributed also on behalf of the ELI to a response to the Commission consultation on the Digital Services Act. So this is another output, if you like, both of the project team on online platforms and of the Digital Law SIG. So thanks again and all the best of success. There's not just SIGs, but there is a second trophy on my desk. Which reads, it's very difficult to see, I realize, which says Hub of the Year, and also we have a corresponding document that says Hub of the Year. And that was a still harder decision, I have to say. But finally, we realized there was a national hub that published in March a first volume with the papers from the 2019 annual meeting that was published under the title, and I translate it now into English in order not to disclose too much. It was titled Studies on European Jurisprudence. Then there was another volume with materials from another annual meeting that has only just been sent to the press and will be out still this month. In May 2020, they held the 5th annual meeting on European case law. That was, of course, held online. It has more than 400 registrants and more than 250 active people who participated in that event. So a total of 120 papers were presented and discussed at the meeting, which is really impressive. And on 6 November 2020, the 5th, and now you may already guess which hub I am referring to, the 5th Spanish-German meeting on private law will take place. And now that leaves two possibilities. It could be Spanish, it could be German, but it is Spanish. So again, once more, the award goes to the Spanish hub. We're really impressed with all the activities, and I hope that Albert or another representative. Albert, hello, I'm relieved you're there. I almost thought you're not here. So Albert, we have to engage in the same procedure now. So I will, move this towards the camera, and we all have to imagine you're taking it over. So it's now in your hands. Albert, it's really great what you're doing. So how do you manage to attract so many participants for your events?
Well, thank you very much, dear President, dear colleagues. Good afternoon, everyone. Both in my name and of my co-chair, Carmen Jerez, and the other members of the Spanish Hub, I would like to thank the European Law Institute for this award. As you all know, last year has been far from being an easy one for Spain, for a number of reasons. When Spain as a country was just starting to leave a terrible economic and social crisis behind, another crisis, this time of a political nature, started, mostly because of the Catalan move towards independence. As if the situation wasn't complex enough, the coronavirus pandemic has been hitting Spain in a rather hard manner, as you all know. In spite of the circumstances, we have humbly try to keep the ELI flame burning in our country. As usual, we have tried to do so by getting as many national members involved in our activities as possible, inviting the best experts we could find to take part in the same, disseminating the ELI message among Spanish lawyers and other legal operators, and asking for support of several institutions, several of which, like the Land Registry Bar, the Colegio de Registradores, have been so kind as to help us in a decisive way. Because of the lockdown and the general situation, our last annual meeting, as our president just mentioned, a meeting which was initially planned to be held in the wonderful city of Seville, also had to take place online. Unfortunately, we weren't able to enjoy the company of our colleagues and friends in person, or the delicious Andalusian tapas, why not to say so. But going online allowed us to gather even more participants than usual and to transcend physical barriers by reaching also lawyers from other Spanish-speaking countries for the first time. During last year, as our president also mentioned, we added a further volume to the collection of materials of Spanish case law, a series which explores the impact of the case law from the European Court of Justice and the European Court of Human Rights into Spanish domestic law. Yet another book, more than 1,000 pages long, is being sent to press as I speak, and 2 more are on their way. All volumes are published by a major publishing house in Spain called Cepin, one of our strongest supporters. All this, I mean, there is no secret. I mean, all this is made possible by the collaboration of many, many colleagues and friends, above all, the members of the Spanish Hub Scientific Committee and the panel moderators who moderate the sessions. Of course, I cannot but express our deep gratitude to the continuing support of the ELI, in particular the Executive Committee and the Spanish members in the Council. And I'd also like to specifically mention the wonderful job which is done by the ELI Secretariat staff, as has already been mentioned this morning by our president. So both co-chairs, Carmen Jerez, who unfortunately couldn't make it today, but sends her greetings also, we both feel truly in debt with the Institute for having allowed us to chair this hub so far. We feel really privileged for that. And the best award for us is actually to be able to keep doing it. So once again, thank you very, very much.
Well, thank you. And also we're really proud of what you're doing. Now, the 2 of you have been so imprudent as to disclose some of the secrets of your success. And this was, you know, a measure to maybe, you know, improve competition among the SIGs and the hubs. So now all the other hubs and SIGs heard what made these 2 communities so successful as they are. Of course, the really impressive list of all your activities may have sounded also a little bit discouraging to others, but it was meant as an encouragement. All these trophies are meant as an encouragement, really. And given that it was such a close thing to make the decision, we are absolutely confident that there are also other hubs and SIGs in the pipeline that might compete next year. So don't be too sure of yourselves that you will again next year. So keep going, keep making all the efforts, but also the others, please keep supporting the ELI. And just to confirm once more how important the work of hubs and SIGs is for this organization. It is with these words, colleagues, that I would like to say goodbye for this evening. There are 2 more days of ELI meetings. Today we had the opening of the annual conference with the welcome address of Minister Zadic and the keynote speech of Commissioner Reinders. That was well attended. We had now the Young Lawyers Award and the Hub and SIG Awards. But tomorrow we will start with the panels on our projects, both the current projects and potential forthcoming projects, plus other topical issues. And I really hope to see all of you and many more during the coming 2 days at our panels. Just to remind you, if you haven't signed up yet, it's not too late. Just click on the relevant links in the program. It's very quick. You will immediately be sent an email telling you, you know, that you're registered and providing you with the relevant link. So don't believe that the fact you haven't registered yet means you can't take part in the panel. Yet it's important to register because we also have to make sure that our Zoom meetings are not disturbed in any way. So again, good night. Congratulations to everybody who received an award tonight. You will be sent the real trophies and the real documents in due course. We will promise to be quick, so that you can already, you know, watch out what is a good place on your bookshelf or wherever you would like to put that, but it may take some days. So again, have a great evening, congratulations, and see you all soon again.